Alec Baldwin's defense team files a motion to dismiss the indictment against Alex Baldwin. Completely dismiss it. Go home. No trial. You're free to go. Don't worry about these charges. And we're going to break down this motion and explain whether this actually has a chance of being granted. And if you've been following this channel, then you'll know that we did a very similar breakdown in exactly what happened in the Karen Reed case. This is almost exactly the same. Karen Reed, also her defense attorneys, filed a motion to dismiss the indictment because they felt that the grand jury proceedings were compromised. And that's similarly the arguments that are going to be made in this motion. Now, the difference is that we are in different jurisdictions. And because you're in different jurisdictions, right, Karen Reed's case is in Massachusetts, and this case is in New Mexico. So there's different laws governing each jurisdiction. So not necessarily the analysis that we gave in the Karen Reed case is actually going to carry through in the New Mexico case. So we have to really analyze this through New Mexico law. Nevertheless, Alex Baldwin's team filed a 52-page motion requesting the indictment be dismissed. Now, before we get into the substance of this motion, I just want to talk about Alex Baldwin's defense team. Who exactly did he decide is going to represent him? So the firm is called Quinn Emanuel, and I may butcher this name, Quinn Emanuel, Urquhart, and Sullivan. It is what you would call a silk stocking law firm. It is a big city law firm. You can go look up their website. You'll see they have like 150 attorneys that work for them. And by all means, go look at each of the profiles of the attorneys. They usually went to a top law school and have a lot to offer in what you would think in the legal profession. So, for example, the first attorney listed is a fellow by the name of Luke Nikas. You can go look him up, look up his profile. Luke Nikas graduated from Harvard Law, and I think he graduated magna cum laude. So a very intelligent person, by all means. There's no question. Much more intelligent than I am, most likely. Then you have Alex Spiro, Michael Nasanchuk, Sarah Clark, and they also got local counsel Heather LeBlanc. But if you look up, they have already 4 attorneys listed on the caption. And this is a big law firm from New York City. And they're going to be coming to New Mexico to try this case. And something that you have to always be wary of, and I don't think people understand this really, but Alex Baldwin didn't ask my opinion. Something that you have to always consider is that it's not just that you want the most brightest attorney working on your case who can research the best and write the best. Yeah, that's important too at certain stages of the trial. But when you actually go to trial and you're speaking to the jury, they may not always appreciate a big city attorney coming into their town and talking what they may feel is down to them. And something that I speak about is that if you're an attorney and you have to do a trial in a different jurisdiction that you're not familiar with, it's a good idea to go there before, sit in the breakfast houses, sit in the restaurants, go to the bars, see what people are talking about, try to blend in and see what is important to these type of people. And that way it'll prepare you how to talk to this jury. You have to connect with the jury. It's not just about coming in and making these arguments and wearing your $5,000 custom-made suits. It's not always going to work. So you got to really be able to figure out a way to connect to the jury. And you always have to consider whether just because these people went to Harvard or they've represented these Fortune 500 companies in different litigation, does that mean that that's going to translate into a good trial attorney who's going to be able to try your case and convince the jury that you're innocent? So it's just something to consider. But when you're dealing with a big law firm, I just want to make this mention also. When you're dealing with a big law firm, it's very difficult if you are a much smaller law firm to be able to go on the other side of them. Why is that? Not because we're any less capable. I would submit that I'm just as capable as any of these attorneys in these big, highfalutin law firms. But for the simple matter is that you're just overpowered. They have 4 attorneys right now listed on the caption. Each of these attorneys most likely have a paralegal or a number of paralegals and legal assistants that help them. And they're going to be what we call papering you to death. They're going to be filing 52-page motions and attaching hundreds and hundreds of documents of exhibits. And they may be filing one of these a week. And you're just going to be chasing your tail, just trying to read everything and research everything that they quote. And they don't always quote the standard cases. They quote all these interesting citations to different authorities. And you're going to be running up trying to find where they're citing for in order to argue back. So when you're dealing with a big law firm, you can expect 52-page motions, which really the arguments could have been made. I think if I was making this argument in this motion, I think I could have done it in half the pages, at least. But it's a big law firm, so they want you to sit down and have to read these 52 pages, and they want you to have to look up the law and the different case law, and they want you to look up all their citations and watch the videos that they're citing to, and all that stuff. So that's why it's difficult. But this is something that we can expect. So although this is a 52-page motion, which I read, and I did it for you, and we're going to be going through a lot of it, not all of it, but some of it, the important parts, I think really the issue comes down to really two arguments. That's what I really think this all comes down to, really two arguments. But, it's a big law firm. They're going to want to paper you to death. And in the back of their mind, they may have the idea that, every hour that they bill now could be $1,500 or whatever they're charging Alec Baldwin. So, in the back of their mind, it's not going to hurt if you spend another hour preparing this motion when really you could have been doing it in less time. But let's move on to the actual motion itself. So this is their preliminary statement. And it's interesting because it does go through a lot of the facts about what led up to where we are today. But it's also interesting how they frame everything and how they start off. So here we go. Nothing is more central to our system of justice than a fair and impartial jury. As Thomas Jefferson put it, trial by jury is the only anchor ever yet imagined by man, by which government can be held to the principles of its constitution. So too for the grand jury. The grand jury, and this is a quote from a case, the grand jury is our system's foundation for the protection of individual rights and a recognized method by which the public can be certain of protection against abuse of public responsibilities. The prosecutors obtained, that was the end of the quote. Now this is going back into the actual brief. The prosecutors obtained the indictment against Alec Baldwin by circumventing this fundamental protection over and over and over again. Oh, what a strong way to start out. Some people may feel that that's very strong, and some people may feel, can you get to the point already? All this nice talk about Thomas Jefferson, let's just get to the point. But this is how they start off. The criminal case against Baldwin started in January 2023, when the Wall Street Journal called Baldwin's attorneys to inform them for the first time that Alec Baldwin was being prosecuted for involuntary manslaughter. Immediately after, the state announced the decision publicly and went on a viral press tour to tell the world that Baldwin was guilty and faced a mandatory minimum 5-year prison sentence. The state's approach came by surprise. The state had promised to inform Baldwin well in advance of making such a decision. It also posted on Facebook the day before that it would be making a quote-unquote somber and respectful announcement of its charging decision without making any public appearances. It broke these promises. Oof. It broke its promises. They're already starting to paint the prosecutor as these bad faith individuals, and it's just going to get worse from here. The state's unethical disparagement of Alec Baldwin was a sign of things to come. The state violated the ex post facto clauses of the U.S. and New Mexico constitutions by charging Baldwin with a firearm enhancement that had not been enacted when the accident occurred. Doesn't that smell like bad faith? How can you charge somebody for an action they did, let's say in 2020, and the law was only created in 2024? You can't go backwards in time and charge everybody who ever committed a crime with new laws that you came up with years later. And this is exactly what this prosecutor did. The district attorney, and I may butcher her name also, I'm sorry, Mary Carmack Altwise, appointed special prosecutor Andrea Reeb to pursue Baldwin, even though she, Mary Carmack Altwise, was simultaneously running for a seat in the New Mexico legislature. Reeb told Carmack Altwise in a private email exchange that she wanted Carmack Altwise to announce her involvement in the prosecution because it would help her election campaign, writing LOL at the idea of minting her political career in the Republican Party by knocking down Alec Baldwin. When Baldwin filed motions challenging the state's unconstitutional conduct, the state withered. Carmack Altwise dismissed the firearm enhancement, so she did the right thing, and Reeb resigned. Publicly, however, the state disparaged Baldwin and his counsel to divert attention from their misconduct and elementary legal mistakes. I mean, they in this brief, they really dig into this prosecution. These prosecutors, really, as we're seeing right now, to divert attention from their misconduct and elementary legal mistakes, calling Baldwin's counsel fancy, big city lawyers who cared about nothing more than billable hours. And of course, we don't just care about billable hours here. All right. The world was appalled. Commentators noted the prosecutor's unethical behavior and constitutional violations, and prominent judges, attorneys, and scholars uniformly criticized the merits of the state's case against Baldwin. Now, does this really have anything to do with the actual issue in front of the court? No. But still, they want to paint this prosecutor and this whole prosecution with this big paintbrush of completely bad faith actors, and they're just terrible. They break promises and they make elementary legal mistakes, nothing that us big city attorneys would ever do. And, that's how they're trying to paint these prosecutors. Carmack Altwise resigned shortly after Reeb, and she appointed special prosecutors Carrie Morrissey and Jason Lewis. For a moment, things were different. Morrissey and Lewis dismissed the case against Baldwin in April 2023. We all are familiar with Morrissey from the Hannah Gutierrez trial. So, for a moment, things were different. Morrissey and Lewis dismissed the case against Baldwin in April 2023 after Baldwin's counsel proved to them accurately that the gun was modified and that the state had overlooked dozens of legal issues and facts. The summer passed without event. It's like a book. Then in October 2023, more than 2 years after the accident and 6 months after Baldwin thought this wrongful prosecution was behind him, the case came back again. Morrissey announced her intention to present the case against Baldwin to a grand jury, as well as the November 16th, 2023 date of the presentation in an interview with the New York Times. She made false statements about the evidence and Baldwin's guilt in that article as well. So now they're shifting first they were painting the first prosecutors in this case, Carmack Altwise and Reeb, with this, they're just bad faith. And now, for a moment, it looked like Morrissey was actually going to act properly and ethically, but now we're starting to sense a buildup that, no, Morrissey is no better than them. She made false statements about the evidence and Baldwin's guilt in that article as well. A few weeks later, Morrissey served a target notice on Baldwin, from which she removed the 48-hour deadline for the submission of Baldwin's grand jury alert letter to shorten Baldwin's time to prepare the letter. All right, let's pause for a second and explain that. What's a target letter? A target letter is when there is a target. The target is the person who you're trying to indict. Okay, that's the target. So you have to give notice, according to under New Mexico law, you have to give notice to the target, meaning the person who you're trying to charge, in this case, Alec Baldwin. You have to give them notice that you are going to be holding a grand jury proceeding. And generally speaking, they leave a 48-hour deadline for the submission of an alert letter. An alert letter is when the target, in this case would be Alec Baldwin, would, in this letter, give evidence and refer to documents and exhibits and witnesses that can show that he's innocent. That's what the alert letter is. So normally there's a 48-hour deadline, but she removed that deadline. Morrissey admitted to Baldwin's counsel that she had never seen this deadline removed. So she's never seen a 48-hour deadline removed. It doesn't make sense that all of a sudden it got removed from the notice sent to Alec Baldwin. But then stated illogically that she just wanted to ensure that Baldwin was being treated like everyone else. In fact, Morrissey had served a target notice on Hannah Gutierrez-Reed, as we all are familiar with already, the same day. That included the 48-hour deadline that Morrissey removed from Baldwin's notice. Here we go again. Really bad faith here, isn't it? How can you say that the same day that you put the 48-hour notice in this document and you served it on Hannah Gutierrez-Reed, but somehow that 48-hour deadline was removed when you sent that same day a similar notice to Alec Baldwin? At the same time Morrissey was attempting to tilt that playing field, she also made the unprecedented request to unilaterally voir dire the grand jury. What does that mean? Generally speaking, in the grand jury, you don't have voir dire. Voir dire is jury selection, essentially. You ask the jury certain questions about the case, the burden of proof, things like that, and you, right, during jury selection in a regular trial, that's what you do. Well, during grand jury proceedings, you don't do that. Generally speaking, there's no voir dire. And here, Morrissey made the unprecedented request to be able to voir dire the grand jury. Now, something important to know, that even in New Mexico law, there's no other attorneys that are allowed to be present. The defendant or the target is not allowed to have his attorney present at the grand jury proceedings. So this would be a completely one-sided voir dire. And that's what they're saying, why it's so unprecedented, and still she made that ridiculous request. The court denied the state's frivolous requests and moved the grand jury date from November 2023 to January 2024. So initially it was going to be held November 2023. The court moved it to be held January 2024. It also expressed concern that the grand jury date and facts about the grand jury process had been disclosed to the New York Times, for which the state was solely responsible. So the judge said he doesn't like, or she doesn't like, that anything was disclosed to the New York Times about the grand jury proceedings. The court noted the prejudicial nature of these disclosures. In this very case, the court explained that a member of the sitting grand jury had asked the court if he could sit on the grand jury that would hear Baldwin's case. He wanted to hear Baldwin's case. The court therefore ordered the parties to refrain from disclosing anything about the grand jury process to the press while the process was ongoing. So while we're choosing this grand jury, you're not allowed to talk about what's going on to the press. Within 1 hour, however, Morrissey violated the court's order by disclosing the content of that hearing to the press, including the new grand jury date, even after the court admonished her about the serious prejudice that could arise out of precisely that disclosure. Baldwin therefore filed a sanctions and contempt motion, which prompted Morrissey to violate the court's order a second time. So Alec Baldwin's team filed a motion for sanctions because an hour after this order that no one is to talk to the press, Morrissey spoke to the press. This is the argument that they're making. So they filed a motion for sanctions against Morrissey. And then after they filed that motion for sanctions, Morrissey went and violated the court's order a second time because she also disclosed the contents of that motion to the press. So she told the press, oh, look, they just filed a motion for sanctions against me. And that, again, you're not allowed to talk about what's going on here. Baldwin next submitted an alert letter identifying significant exculpatory and favorable witnesses and documents, as well as jury instructions on the relevant offenses and defenses. But the state refused to present nearly any of that evidence to the grand jury, supporting its position with old case law that had been overruled by the New Mexico Supreme Court and New Mexico statutory law. The state also refused to read Baldwin's proposed charging instructions to the grand jury. So what did the Baldwin's team do? This alert letter, which we just spoke about before, they sent this alert letter to Morrissey, to the prosecutor, and it identified all of this exculpatory evidence and witnesses and documents. And they also submitted a proposed jury instruction, which she should tell the jury. But the state refused. The state refused to read Baldwin's proposing charging instructions to the grand jury, noting that it would read a different instruction about intervening cause. Intervening cause has to do with proximate cause. So if there is an intervening cause, that would disturb whether this action of Baldwin was the proximate cause. Even though the state's preferred instruction stated that it did not apply in homicide cases. So they're trying to point out how just completely off the ball Morrissey is, and how she's acting in bad faith and blatantly violating court orders. Now, as we continue with this, you're going to be thinking, well, I imagine that the reason why they're going to be asking for a new for the indictment to be dismissed is because of all of these actions that she's taking. And you're kind of right. But it's going to actually change a little bit. We'll see. The state therefore filed a motion seeking permission to disregard Baldwin's alert letter. So now, Baldwin's team filed this alert letter, which they're allowed to do, which they're supposed to do, identifying exculpatory evidence. And then the state, Morrissey, filed a motion seeking permission to disregard the alert letter. The court denied the state's motion with respect to the evidence. The court ordered the state to make nearly all the favorable evidence and witnesses available to the grand jury. So the court did not agree with Morrissey. The judge says, no, you have to abide by the rules, and which would mean that anything that they put in that alert letter has to be made available to the grand jury. As for the jury instructions, the court ordered the state to provide Baldwin's requested instruction on the issue of intervening cause if the evidence supported it. And the court ruled that the state's instruction about involuntary manslaughter must precisely track the uniform jury instructions. So, two important rulings that the court made here. Let's just explain this. The court made two very important rulings. Number one, that the alert letter and all of the evidence and the documents and the witnesses have to be available. And they have to be available for the grand jury. That's number one, court order. Number two, court order is that the jury instruction that the prosecutor is to read to the grand jury must precisely track the uniform jury instructions. Meaning she's not to add anything, add context or explanation, just read the uniform jury instructions. So those two things, two orders, two rulings. The court's ruling came just days before the grand jury presentation was set to start, which, given the grand jury schedule, left only 2 days for the state to present the entire case before the grand jury's term expired. So the grand jury terms expired in another 2 days. And now, when the court made this ruling, the prosecutor, Morrissey, only had 2 days. And I hope I'm not butchering her name also. If I am, I apologize. But the grand jury had only 2 days to listen to this case and decide whether they're going to hand out an indictment or not. Baldwin warned the state in writing, meaning his attorneys, warned the state in writing that it would not have enough time to present the evidence from his alert letter before the term ended, meaning his attorneys submitted so much, as I was talking about before. They had submitted so many documents and so much evidence and so many witnesses that should be available that they didn't think that there'd be enough time in just 2 days to present all of that evidence. And therefore, he asked the state to adjourn the grand jury date to ensure his evidence could be presented. But the state ignored Baldwin's letter and jammed through his presentation in barely more than 1 day. The state did so by violating nearly every rule in the book. It did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. It did not tell the grand jurors that they had the right and, in fact, the obligation to request and hear all exculpatory evidence. So the prosecutor did not tell the grand jury, the grand jurors, that they had a right and even an obligation, which they're going to quote from a statute in a minute, or a rule of criminal procedure, the obligation to request and hear all exculpatory evidence. So they're arguing that the prosecutor had a duty to tell the grand jurors that they have a right, and not only do they have a right, but they have an obligation to request and hear all the exculpatory evidence. And then they quote a statute. Here it is. And this is the quote of the statute. It is the duty of the grand jury, and they quote the statute a lot in the rest of the brief. It is the duty of the grand jury to weigh all the evidence submitted to it, and when it has reason to believe that other lawful, competent, and relevant evidence is available, that would disprove or reduce a charge or accusation, or that would make an indictment unjustified, then it shall order the evidence produced. So therefore, the Baldwin's team, the defense team, is saying, since that statute says that the grand jury shall order that that evidence be produced, which would disprove or reduce the charge, that means that they have an obligation. Shall is you're required to do it. It's an obligation. And this was never explained to the jury, to the grand jury. The prosecutor had a duty to explain this to the grand jury. The state did not make Baldwin's witnesses available to testify. So one of the things that they're required to do under the court's order, the prosecutor was required to do, was to make Baldwin's witnesses available in case the grand jury wanted to hear testimony from them. And the state did not do that. Nor did it present the exculpatory and favorable evidence to the grand jury. So it didn't even present those documents, didn't present the exhibits to the grand jury. When grand jurors asked questions about exculpatory witnesses or facts, the state instead forced them to hear answers from the state's chosen and usually paid witnesses, even when those witnesses had no personal knowledge or foundation for giving testimony about the subject. So now they're making the argument that sometimes the grand jurors would actually ask questions, which the only people that could answer those questions were the witnesses that were identified in the alert letter. And yet the prosecutor allowed other witnesses to get up and talk about and answer those questions without the knowledge or foundation for being able to give that testimony. And to top it all off, the state read the grand jury an involuntary manslaughter instruction that violated the court's order, unfairly stacked the deck against Baldwin, and contained language that was inconsistent with both the UGI, the Uniform Jury Instruction, and the state's own opposition to Baldwin's request for a different instruction. The state prosecutors have engaged in this misconduct and publicly dragged Baldwin through the cesspool created by their improprieties without any regard for the fact that serious criminal charges have been hanging over his head for 2.5 years. Enough is enough. This is an abuse of the system and an abuse of an innocent person whose rights have been trampled to the extreme. The court should dismiss the indictment. And that is their preliminary statement. Okay? And now they go through what they call the next step, which is the factual background, which is very similar to what we just heard, just with a little more context. So we're going to be jumping through that stuff, not going over that stuff, because we really basically explained it all. Now, another interesting part of the brief, and then I'm going to get eventually down to what I think this really comes down to. On November 15th, 2023, the court held a hearing to discuss the parties' pending motions, as well as the grand jury schedule. The court first stated that given the length and breadth of the state's motion to preclude Baldwin's requested evidence, the court was vacating and rescheduling the grand jury from November 16th, 2023 to January 18th, 2024. So this is when, as we referred to earlier in the preliminary statement, this is just a little bit more context that on November 2023, the court held a hearing and said, you know what, the grand jury is not going to go ahead on November 2023. We're going to adjourn it to January 2024. The court also postponed argument on the state's motion to give the court time to review the parties' submissions, the exact solution that Baldwin had originally proposed to the state to ensure this process is done properly the first time around. Now, here is another attack on the prosecution. Remember, we spoke about in the preliminary statement that within 1 hour after the court ordered that no one is to talk to the press about what's going on in these grand jury proceedings, they made an argument, Alec Baldwin's team made an argument, that the state violated this. So listen to this. The state violated the court's order within 1 hour by disclosing details of the hearing to the press, including the new grand jury date that the court had instructed the parties not to disclose. Baldwin therefore filed a sanctions and contempt motion, which prompted the state to violate the court's order again by making improper disclosures about those filings. And listen to this. As if things couldn't get worse. In these discussions, the state also revealed its illicit motivations behind this prosecution, as reported in the article. And here's the quote from the article. Prosecutors haven't said publicly what new evidence they have obtained during their months of investigation. But a source familiar with the case said the special prosecutors have had discussions in which they said they hope the trial will humble Baldwin, specifically citing his run-ins with paparazzi and public comments that weren't about the case. The source added that the intention is for it to be a quote-unquote teachable moment for Baldwin. The following morning on the Today Show, the press added that the special prosecutor said that they were also targeting Baldwin because they think he's arrogant. This was a stunning and extreme abuse of prosecutorial power, consistent with the state's motivations from day one when Reeb told Carmack Altwise, and I'm sorry about her name, that prosecuting Baldwin would help her election chances. So even more fuel for the fire here. Now, on January 11th, 2024, so this is already getting into 2024, the court overruled most of the state's objections to Baldwin's evidence. So said all this evidence is able to come in if the jury needs it, and held that the grand jury must be told about nearly all of the evidence the state had sought to exclude. So the judge said they have to be told, the grand jury has to be told about all this evidence. Everything that's in the alert letter, and the grand jury has to be told about that. To begin with, the court explained that the state needed to facilitate the grand jury's inquiry into any lawful, relevant, and competent evidence not initially presented by the state and cannot unilaterally withhold evidence or witnesses requested by the grand jury. So if the grand jury requests a certain piece of evidence or a certain witness to come testify, then the state needs to facilitate that to happen. All right? Let's continue. In a separate order issued that same day, the court cautioned the state that it must provide Baldwin's requested proximate cause instruction if the evidence supports this provision to the grand jury. So that we also spoke a little bit more about earlier. Another interesting development that I noticed in these papers, which we're probably going to be hearing more about in the trial, if there is a trial. Listen to this. So they're going through exactly what happened during the grand jury proceedings, the different witnesses that were called, and how that entire process went. So listen to what they say here. After Hancock and Poppel, the state called Michael Hagg, one of the state's purported firearms experts, to testify that the firearm would not have fired on the day of the incident unless Baldwin pulled the trigger. And remember from the Hannah Gutierrez retrial that this was an important part. And this is not something that really the defense argued about too much. I think it was good for them. The fact that the only way that the bullet was able to be shot out of that gun was if Baldwin pulled the trigger. Now that would be helpful for Hannah. It's not so helpful for Alex. So they don't want to concede on this issue. So listen to what they say. Hagg, who had no personal knowledge of the testing, summarized the testing that had been conducted by the FBI, during which the firearm was beaten with a mallet and destroyed. If you remember watching that trial in the Hannah Gutierrez retrial, he spoke about how they actually hit the gun with a mallet, and they eventually broke the gun that way, without preserving any evidence of its condition when the accident occurred. So they didn't provide any evidence. They didn't preserve any of the evidence of the condition of the gun before they broke it. They did obviously preserve some parts of it, but they're going to make arguments that they didn't preserve all of the different parts of it. Hagg omitted several essential facts regarding that testing, including that the FBI testing established that the gun did fire without a trigger pull when the firearm was fully loaded with 6 rounds, as it was on the day of the incident. So this is going to be news for everyone who's following this case and who followed the Hannah Gutierrez retrial. Because now it seems that there is a report from the FBI lab report that the gun did fire without a trigger pull when the firearm was fully loaded with 6 rounds. And that's exactly how it was on the day of the incident. So now we're starting to, think, wait a second, there is some testimony, there is some evidence that gun, maybe the trigger was not pulled and it still somehow was able to fire. Notwithstanding this fact, of which both Hag and the prosecution were aware, Hag testified repeatedly that the firearm could not fire without a trigger pull. So they're saying Hag and the prosecutor both knew about this report that said it is possible for the gun to fire without the trigger pull, and they both didn't bring that out. That's another point. Now, the state's next witness was Brian Carpenter, who, like Hag, was paid by the state to testify. We all remember Brian Carpenter. He was this really seems like a very big expert in firearms, an expert armorer. Now listen to this. In media appearances, as well as on LinkedIn and in the CV he provided to the state last spring. CV is just curriculum vitae, which is the same thing as resume. So in media appearances and on LinkedIn and in his CV, Carpenter represents himself as an armorer and weapons expert. So that's what he is. He's a weapons expert and he's an armorer. But that is not how he represented himself to the grand jury. Instead, he introduced himself as the owner of a production studio that makes movies, as if he started as an armorer but has since taken on bigger roles in the industry. That testimony was false, and Morrissey knew it. Carpenter is not an experienced film producer. Carpenter's studio, 13 South Productions, appears to have been involved in no more than 1 or 2 projects that were distributed to the public. The studio's IMDb page lists 4 productions, 3 of which appear never to have been released. So here you got this guy, Carpenter, getting on the stand and saying to the grand jury that he is the owner of a production studio. And really, he's not the owner of a production studio. They made one production there. So what's the big deal about that? Now, this misrepresentation allowed Carpenter to testify well beyond his experience with credibility that he didn't earn. So, first of all, let's just calm down a second. It's not false, right? He does have this production company. So it's not false. Maybe it's just not completely being 100% truthful about how many productions he's made, but he is the owner of production. He is the owner of a production studio. But they still don't like that they're playing this game. For example, Carpenter told the grand jury that the safety bulletins issued by the Screen Actors Guild, SAG, place responsibility for firearm safety on the actor. So now they're going to get into patently false testimony that he testified to. So Carpenter said to the grand jury that the safety bulletins issued by SAG place responsibility for firearm safety on the actor. In fact, SAG has made the opposite statement. An actor's job is not to be a firearms or weapons expert. Firearms are provided for their use under the guidance of multiple expert professionals directly responsible for the safe and accurate operation of that firearm. And the firearms bulletin makes clear that the actor has no obligation to check the gun. So here, they're just saying that Carpenter just said something wrong, absolutely wrong. Carpenter also falsely testifying that the SAG safety bulletins bar actors from pointing the weapon at anything you're not willing to destroy. That was something that he also mentioned, that you never point the weapon at something unless you want that thing to be destroyed. The safety bulletins don't say that. That's another argument that they say. The state's final witness, listen to this, Connor Rice, is a paid private investigator and former Albuquerque police officer with a sordid past. What type of sordid past does he have? Well, if you look at the footnote here, footnote says in 2013, Rice was charged with beating a man as the man was surrendering during an arrest. Video from the arrest shows Rice punching the suspect in the face 3 times while another officer puts his boot on the suspect's head. So, lawsuit there probably waiting to happen. Well, not waiting to happen, 2013. Maybe it happened already. Anyway, continuing. Morrissey never contacted Baldwin's witnesses to ensure they were available to testify. That was another order by the court that Morrissey has to make the witnesses available to testify, even though the court ordered the state to make Baldwin's proposed witnesses, quote unquote, readily available. That was what the order said. To testify without scheduling disruptions. The state knew it was obliged to do so, but it excluded these witnesses from the grand jury proceedings anyway. So here's another thing. They didn't do that. The state accomplished this in two ways. First, Morrissey did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. So now you may be wondering, well, what happened to that alert letter? Did she actually do anything with that alert letter or not? So this is what they say. Morrissey did not explain the meaning or purpose of Baldwin's alert letter to the grand jury. She introduced the letter at the beginning of the proceeding by stating simply, there is a grand jury alert letter from the target for your consideration. She then proceeded to read the alert letter into the record verbatim, without explaining its practical significance, why it had been submitted, why it was being read, or what the grand jurors were supposed to do with it. All she did was read the letter. She has to provide a little more explanation as to what's going on in that letter. That's part of the argument here. Nor did Morrissey explain that the witnesses identified in the alert letter were available to testify and that the grand jury was obligated to request the presentation of exculpatory and relevant evidence. So here we go again. They're making the argument that Morrissey did not explain that the witnesses that are identified in the alert letter are available to testify if you'd like to hear them. She didn't tell that to the grand jury. And also, she didn't tell the grand jury that they were obligated to request the presentation of exculpatory and relevant evidence. And again, they quote this statute, which we quoted earlier. It is the duty of the grand jury to weigh all the evidence submitted to it. And when it has reason to believe that other lawful, competent, and relevant evidence is available that would disprove or reduce a charge or accusation, or that would make an indictment unjustified, then it shall order the evidence produced. Instead, Morrissey conveyed the exact opposite impression. Before reading the alert letter, she had already dictated who the witnesses would be, informing the grand jury that this morning, this is what she said, this morning I will be presenting to you a case where Alexander Baldwin is the target. The witnesses in this case will be Corporal Alexandra Hancock, Marissa Popple, Michael Hagg, Brian Carpenter, Ross Diego, Lane Looper, and Connor Rice. And after reading the alert letter into the record, Morrissey made no effort to explain the letter's purpose. She simply stated that concludes the grand jury evidence alert letter from the target, so there are witnesses ready to testify now. However, it depends on what you want to do. Do you want to take a break to consider the alert letter, or do you want to just begin hearing witness testimony? So hold on a minute. Now she did say, do you want to take a break and consider the alert letter? Morrissey never explained or even attempted to explain what it meant for the grand jury to consider the alert letter. Why would she just say, do you want to take a moment to just consider this alert letter? That's all? I.e., that they could ask for any witness or document identified in the letter. She didn't explain that, and by the way, what it means to consider this a letter is that you can actually ask for witnesses to testify or ask for documents identified in this letter and read it and hear from the witnesses. And in fact, and they keep coming back to this, we're required that the jury was required to order exculpatory evidence to be produced. Once again, her statement communicated that the opposite was true. Her message was that the grand jury could consider the alert letter, i.e., read it themselves, or just begin hearing witness testimony. The state never explained that there was a third option. The most critical option of all, under the governing law, the grand jury could consider the alert letter, hear witnesses the prosecution identified, and direct that the witness testimony and documentary evidence identified in the alert letter be presented. So she didn't do that. Another instance that happened in the grand jury proceedings. On another occasion, a grand juror asked, when Alec Baldwin refused to look at the gun that was handed. Listen to how the grand juror asked this question. When Alec Baldwin refused to look at the gun that was handed, that was allegedly cleared, and they gave it to him to re-inspect it, how would he inspect the gun? Would he take all the bullets out into his hand and start shaking them, or would he just open the chamber and look at the top, make sure that it was kind of seated all the same and no inconsistencies? That was the end of the juror's question. The question itself, this is the argument from Alec Baldwin's attorneys. The question itself is troubling because it reflects at least three material misunderstandings. Number one, that Baldwin, quote unquote, refused to look at the gun. Two, that he was required to reinspect it once it was handed to him. And three, that there is a protocol for actors on how to check the weapons. These misunderstandings are the direct result of false testimony, which we spoke about earlier, from Morrissey's witnesses, and Morrissey had a duty to elicit truthful evidence to rebut them. Okay, and then they talk more about the jury instruction where Morrissey did inject some of her own language into the jury instruction. And this is the language that she injected into the jury instruction, which was not following the uniform jury instruction, which is what the judge told her to do. The judge said you're not supposed to add in any extra language. You just read from the uniform jury instruction. Well, here it goes. Morrissey supercharged these failures by issuing an improper instruction on a critical element of the charging statute. Specifically, on three separate occasions, Morrissey instructed the grand jury that to return a true bill under New Mexico 14-231, it must find probable cause as to each of the following elements. Number one, the target discharged a firearm during the production of the movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. All that I added, without first verifying the firearm contained no live ammunition, that was all added by her. That was not from the uniform jury instruction. And then they continue with the rest of the jury instruction, but that's part of their argument, that she's adding to the jury instruction when the court specifically said you can't do that. Now, this is where it actually talks. Okay, so now that's basically the facts that led up to this. So now we have to understand, well, under the law, is there a problem with what she did? So they quote this case, and the case says the following. A court may review the sufficiency of the evidence underlying an indictment upon a showing of prosecutorial bad faith. So if you can show bad faith, then the court may review the sufficiency of the evidence. What is bad faith? Dishonesty of belief, purpose, or motive, which they believe they have a case showing that that's how she acted. The state had one goal: indict Baldwin no matter the truth, no matter the rules or court rulings, and no matter what it took to do so. If the state's conduct here, listen to this statement, if the state's conduct here does not demonstrate the level of bad faith necessary to subject an indictment to judicial review, it is all but impossible to imagine a set of facts that would. So the first thing that they have to argue is that they have to get into the door. They have to say, first of all, Judge, you do have the authority to review the indictment. And the way that you get into the door is by showing that the prosecutor acted in bad faith, or have at least allegations that they acted in bad faith, in order for a judge or a court to review even the indictment and the grand jury proceedings. So that's what they're arguing here. The grand jury is not meant to be the private tool of a prosecutor, even though it may seem that many times it is. The grand jury does not function as an arm of the prosecution. The indictment, and finally here's what we get to their real request, what they're really asking here. It took 48 minutes, but this is really what they're asking for. And it took, if you're reading the whole thing, it would take you a lot longer than 48 minutes. But here we go. The indictment must be dismissed for two independent reasons. First, the state unlawfully deprived the grand jury of critical evidence that disproves the charges or makes an indictment unjustified. That's number one. And second, the state conducted the grand jury process in an unlawful manner, including by providing an improper charging instruction regarding a critical element of the offense. So really, what does this all come down to now that we spent 48 minutes going through even only just a portion of this 52-page document? It really comes down to two things. The two things are, was the prosecutor supposed to show all of this exculpatory evidence to the grand jury? That's number one. So let's talk about that for a second. So let me make something clear. There's no rule in New Mexico that a prosecutor must provide exculpatory evidence unless it's directly talking to an innocence or guilt. If it's more circumstantial evidence or more this witness against that witness, That's not necessarily what you have to show. That's not necessarily what you have to show to the grand jury. So kind of similar to what we said in the Karen Reed's case, where exculpatory evidence is not required to be presented to the grand jury. That's still true in New Mexico. A prosecutor does not have to show all of the potential exculpatory evidence. There is an alert letter, which could be written by the defense. And also, by the way, the target could testify himself. He can ask to testify. And when he does testify, his lawyer is allowed to be there, albeit he's not allowed to ask any questions. So it's an interesting kind of situation. But that's the only time that the defendant's allowed to be there, or the defendant's attorney is allowed to be there, or the target in this case. Aside from him providing that evidence, all he's limited to is providing an alert letter. Now, under the law, it appears to me that what has to be done is that the prosecutor has to let the jury know about everything that's in the alert letter, which is what technically the prosecutor did here. She did read verbatim from what the letter said. Does she have to do anything further? That's really the question in this case. Did Morrissey, was she required to let the jury know these witnesses are available if you want them? And not only should you want them, but you're required to want them? No, she's not required to do that. The statute quite clearly says that if the grand jury wants, if they feel there's reason to hear from these other witnesses, then they can tell the prosecutor, and then the prosecutor has to facilitate those witnesses coming. That's true. But does the prosecutor have to instruct the grand jury that these witnesses are available and here for your consideration if you want to? And by the way, you are obligated to? Of course not. That seems pretty simple and straightforward in my mind. So I think really, and this is something that if you look through this entire 52 pages, you don't find, which is always a very critical part, is show me the law, show me the statute, show me the rule, which tells the prosecutor directly that she has to do this. They don't have one quote to any case law or to any statute or to any rule that says the prosecutor is required to do this. They don't have that. All they have is a statute that says that if the grand jury wants to hear from the witnesses, then they may be obligated to ask for those witnesses. But that's up to the grand jury. So as long as she read that alert letter to the grand jury and said they have all these witnesses that they think are going to help their case and all these exhibits and documents that will help their case, then you leave it up to the grand jury. The grand jury can be free to ask, well, I'd like to see some of those documents. Can you get me those documents? And then the prosecutor would say, well, yes, now I have to facilitate that. But the prosecutor really doesn't have any overarching duty to provide exculpatory evidence. And that maybe you don't like. And maybe that's something that just rubs us the wrong way, because even in the charging process, maybe the grand jury should hear all the exculpatory evidence as well. But at this point, the law doesn't require it. So therefore, prosecutors are not going to do it just for no reason, just to not get an indictment. So that is, and again, this isn't the entire trial. This is just to get the indictment. So they're not putting on an entire trial here. It's not going to be your witnesses versus my witnesses and your evidence versus my evidence. That's not what the purpose of the grand jury is, at least at this point. So at this point, I don't think their first argument that Morrissey should have explained more to the jury about what their job is and what they should want to see and what they're obligated to see, I don't think that's really the law. And they haven't cited anything that tells us that the prosecutor is required to do that. So that's number one. What about the fact that she didn't read the jury instruction properly? What about that? And she put in words that didn't belong there. That I see as being more of an issue. And the fact that some of the witnesses testified about things that they're really not qualified to testify about, or they made it seem that they're more qualified or to talk about something, or they have an expertise in something that maybe they don't really have, and maybe they're quoting safety bulletins that are really incorrect. That I don't know if you're going to get anywhere with that argument. But here, I think the more concerning argument here is the fact that she violated the court order. As far as I know, the court order said that she's not to deviate from the uniform jury instruction. And it was a very clear order, at least how the papers make it seem. And if she added words to that jury instruction, and therefore the grand jury could have a different understanding of that jury instruction, and that's why they came down with the indictment, well, that might be a problem. So the knee-jerk reaction here is that, generally speaking, grand jury indictments don't get overturned. They don't get dismissed. So if you were a betting person, you would probably bet that it's not going to get overturned, just because that's the way, usually they can find something that there's a reason. And again, we haven't seen the prosecutor's response to this. This is all just the Alec Baldwin's arguments. And we may hear a completely different story from the prosecutor. That is possible. And when that comes in, we'll be able to analyze that. But as it stands now, the way that I see is that it's more of an issue, the jury instruction issue, than the other part of providing the exculpatory evidence. But again, even if that is an issue, will that mean that the indictment should be dismissed? Most of the time, these indictments are not dismissed, and these motions are filed in plenty of cases. So we'll see if this actually gets anywhere. I can't give you such a great answer about whether this is going to. I have to see the prosecutor's response on this before I give you what I think is going to happen. But generally speaking, if you're a betting man, like I said, the bet would probably be that the indictment's not going to get dismissed. But we're talking too early, so we'll wait for the prosecutor to get in. All right. Well, that is it for now on this motion to dismiss the Alec Baldwin case and trial. We'll see what happens with the prosecution's response, and we'll continue to follow this trial. All right. That's it for now. Thanks for joining. If you haven't yet, please subscribe, like the video, and we will see you next time.